Professor of International Law Achilles Skordas, who's based at the University of Bristol, the UK.
Yes, I suppose that the incident with Sudan would be just a parting point for our interview. But since everyone seems to be pointing at Israel, and this has not been proved yet, but in general, some people are saying that a country, a government, is authorized to make some kind of preemptive strikes if it feels that a terrorist threat is coming from another sovereign country.
Well, international law is on some points clear, on some other points less clear. The International Court of Justice has always interpreted the right of self-defense in a restrictive way, both in its advisory opinion on the construction of the wall in 2004 and in the case Congo versus Uganda of 2005. It clearly indicated that the exercise of the right of self-defense against a threat and against something coming from the outside presupposes first an armed attack, and secondly, this armed attack must be attributable to a state. Therefore, international law does not recognize the right of self-defense against non-state actors as such. And international law also does not recognize the preemptive self-defense as it was enunciated by the United States in 2002. Therefore, if this incident, the bombing of the weapons factory in Khartoum, is attributable to Israel, then Israel has the burden of proof that the government of Sudan was planning an ongoing attack against Israel, and I don't think that the facts would establish this claim.
Well, there's been a strike, and there are some witnesses with giving evidence of. So what should the international community, or perhaps what should the Sudanese government do to establish law?
International law is indeed weak in that point. The government of Sudan can bring the issue before the United Nations Security Council, for instance. In theory, the Security Council could decide a fact-finding mission, which I don't find it realistic under the current circumstances. So I have the feeling that the incident will not be sufficiently clarified through international procedures. What the case may be is that perhaps Israel could admit the strike, could justify it, could bring forward information justifying what happened, or perhaps a group of experts may further try to find information based on evidence on the site of the attack. These are some of the possibilities that are open to the government of Sudan and to the international community as well.
So, if I get you right, everything seems to be resting simply on the goodwill of the key actors.
Yes, I'm afraid that there is nothing more that can be done at the present stage. And here I would like also to make a distinction between what happened a few days ago in Sudan and the policy of targeted killings, which is a policy that the United States follows with regard to Al-Qaeda operatives. Now, targeted killings are somehow different because when these policies are implemented, they sometimes have the consent of the states on whose territories the attacks are perpetrated, for instance, Yemen or Somalia. Or sometimes they have the implicit or the explicit approval of the UN Security Council, as it was in the case with the killing of bin Laden. So we should differentiate these policies which are conducted in the course of the fight against terrorism, against Al-Qaeda, and acts which are conducted against third states like Sudan that may or may not provide assistance to groups like Hamas. If the reporting is true that Israel indeed has conducted this attack, there is no consent by Sudan, and there is no right to a preemptive strike connected with potential activities of the Hamas. So the burden of proof is on a high threshold here for Israel.
As far as I understand, there's been several instances in which Israel seems to have committed similar attacks on the territory of Sudan. and it always preferred not to comment on the issue. It has always abstained from any comments, just like in this case. But on the other hand, you mentioned a similar, a preemptive attack which was carried out by the United States, and as far as I understand, there's been several. So does that mean that the international legislation needs to be revised somehow, or is there any way to ensure that the legislation is being followed by international players?
Yeah, here we should recognize the important role of the United Nations Security Council. In fact, the war against Al-Qaeda terrorism has been recognized as a main objective of the international community, and it has been reiterated by many resolutions of the Security Council. Therefore, the Security Council seems to implicitly acquiesce, to implicitly approve the policy of targeted killings against Al-Qaeda terrorists as a strategy in the war against Al-Qaeda. The Security Council has not approved any similar policies against Hamas or Hezbollah. And the difference is not so much in international law as in the policies of the Security Council, which we should keep in mind, has the authority to adopt binding resolutions for the international community. Therefore, it's the Security Council itself which regulates these questions and approves some forms of use of force and disapproves others. But to come back to the question of self-defense, if indeed is an exercise of the right of self-defense, Article 51 of the Charter requires the state that invokes the right to inform the Security Council, give the reasons, so that the international community knows about these facts. And indeed, if Israel or any other country has information of terrorist plannings or of a terrorist infrastructure in Iraq, in Sudan, it should indeed inform the Security Council so that the members would know what the situation is.
Professor, thank you so much. And just to remind you, our guest speaker was Achilles Skordas, Professor of International Law at the University of Bristol.